Hey everyone, welcome back to the VSO Gun Channel. It's great to be here as always. I have some news for you out of yesterday from the Firearms Policy Coalition. They have secured yet another win. This time, and I'm just going to use their language, they have dealt the final blow to the New Jersey carry permit scheme, very similar to what happened in the New York State Rifle and Pistol Association. They had these needs analysis provisions in their law, and that was struck down in Bruin, and now that statute is being scrutinized, or was being scrutinized, using the same constitutional arguments for the Second and 14th Amendment. So that's what we're going to be talking about here today, but I think not only is this good news that the whole unconstitutional method of determining who can have the right to defend themselves and who can't has been struck down, but I think that this situation also might be the first indication of a shift in the methodology of our enemies. And I think it's important to see what was done here because it might actually influence how some of these court cases are litigated in the future. That and more after we hear a quick word from today's sponsor. Today's video is brought to you by Medical Gear Outfitters. They are my go-to stop for anything medical related. It doesn't matter whether you need bumps and bruises kit or whether you need real equipment like chest seals or a cat tourniquet or something like that. They have got a bunch of medical kits over there. Again, they are my go-to shop, and they are great people. I've known Dietrich and the crew over there for going on like 10 years now. So they are definitely a place that you should check out if you're looking to augment your medical equipment needs. And they have a discount code for all of you who are VSO subscribers. You can find that information over on the affiliates page, and special thanks to Medical Gear Outfitters for making today's video possible. Whereas the above-named plaintiffs commenced this action against the above-named defendants to challenge the constitutionality of the state of New Jersey's justifiable need requirement previously enforced through that regulation there as condition to issuance of permits for the carrying of handguns in public by ordinary law-abiding citizens of New Jersey, contending that the regulatory scheme violates the 14th Amendment of the United States Constitution by preventing law-abiding citizens with ordinary self-defense needs from exercising their Second Amendment right to keep and bear arms in public for self-defense. Talks about Bruin for about a paragraph. In light of the Supreme Court's opinion in Bruin, on June 24, 2022, the New Jersey Attorney General issued a directive announcing that the law enforcement agencies shall no longer enforce that regulation requirement of a justifiable need to carry a firearm. They repealed it. The parties desiring that this action be settled by appropriate consent decree and without the burden of protracted litigation agreed to the jurisdiction of the court over the parties and the subject matter of this action. Whereas the court finding that the fees and costs set forth below are reasonable and all parties having consented and stipulated to the following relief and dismissal of this action with prejudice for the good cause shown. It is on the 11th day of July, 2024, hereby ordered and adjudicated and decreed that the court declares that the requirements formally contained in that regulation, that the applicants for handgun carry permits in New Jersey show a justifiable need, violate the Second and 14th Amendments of the United States Constitution. Plaintiffs are prevailing parties and are therefore entitled to reasonable attorney's fees and costs. And then it goes on for a while defining what monies must be paid and by whom. So to translate all of that from lawyer speak to regular English for everybody, the state of New Jersey just gave up. They said, hey, look, we can see FPC coming on this one. Stop enforcing that provision of the law, and the justifiable need is gone to limit their liability. They got sued. And basically, instead of litigating this out for years, they decided to say, hey, we're just going to settle this at the district court level. The Supreme Court has already spoken on this. We don't really have a leg to stand on. Instead of pushing this out for years, we're just going to go ahead and say, yeah, we're going to lose this one, which is substantially different than what we've been seeing when it comes to Second Amendment litigation up to this point. Basically, most of the time, those parties, the defendants, dig their heels in and push these things out for years. And I think in my opinion, what happened here is they've been seeing how those higher court Second Amendment cases have been going, and they don't really like the result because what this does, you'll notice that they said very expensive litigation. What that translates to is further enriching the Firearms Policy Coalition, because they, as you can see, got their attorneys' fees back and all that sort of stuff, but it wasn't really that much money. If they litigated this out for years, then the FPC would have plenty of work to do and the state would have to pay them, and also prevented themselves from getting an additional major shellacking at a much higher court level. So from the district court, it goes up to the appellate court, and from the appellate court, it goes up to the Supreme Court. I think what they're seeing is that these higher court cases are coming back poorly for them, and they don't want to be the people that give the court another opportunity to make landmark decisions as it applies to facets of the Second Amendment regulation. So we saw the broad-reaching implications of the Bruin decision. This is very narrowly tailored as far as this case is concerned as it applies to the Bruin decision, but the Bruin's decision's verbiage of text, history, and tradition of the United States has been rocking the world of gun control since it was dropped. And I think that our enemies see that and they're like, oh, we can't do that again. Versus, like, you see what's going on with, like, the pistol brace regulation. You see it with the frames and receivers. Those people have run headlong into the gate. And that's a cattle reference for any of you who aren't farm people. I'll explain it really quick. Whenever you're working livestock, you use what's called a head gate, and it's a set of bumpers that gently close down around the neck of the animal, and their head's too big, their body's too big, so they're kind of like stuck in this small window of movement, and that allows you to go in and do things to them like change out their identifying ear tag, give them any medicine that they need to have, stuff like that. Doesn't hurt the animal whatsoever, and it is initiated by a voluntary lever that you pull. However, if you get a really squirrely one that's kind of freaked out or just plain old mean or crazy, they will run fast up the chute, and if their shoulders hit that, it has a mechanism that self-traps them, right? So the reference there is that they sprung their own trap. There is fatigue in our community with the constant overreach of the government trying to do this or that that infringes on your rights, to try to find a new angle to accomplish their ill-conceived will, and they keep getting smacked down in the courts. While I understand the fatigue and I feel it myself, whenever I see an appeal, so they lose at a district court or a circuit court, and they appeal that decision up to the higher court, that them being the gun controllers, I actually think that that is a great thing, because what that means is they lost, they're throwing a temper tantrum, they're going to try to take it to a higher court, and what they're doing is pushing themselves closer and closer to landmark decisions. If you force the Supreme Court to make a constitutional call on something like they forced them in the New York State Rifle and Pistol Association v. Bruin decision, you have nationwide, broad-reaching consequences that reverberate through the entire system. And it's a really good thing when they do that. In this instance, they decided that that was probably not a good thing to do because they were going to lose. So keep in mind that whenever you see something like this making its way to the higher courts, that is likely a good thing for your rights long term. So keep an eye on that. This was obviously a win, and FPC should be given a pat on the back. Good job, boys and girls over there. Keep up the good work, and that's why you should be contributing. I am where's my wallet? Card-carrying member of the Firearms Policy Coalition, and you should be too. Thanks for tuning in. Hopefully we'll see you on another video here at the VSO Gun Channel. Be free.